The rapid spread of COVID-19 is causing significant disruption to international trade and the shipping industry. Our Associate Keshav Raychaudhuri discusses the main legal issues affecting shipowners, charterers, traders, and shipyards. What has been the impact of COVID-19 in terms of restrictions on the crews?
So the Baltic and International Maritime Council, the BIMCO as they're commonly called, has stated recently that all vessels and ship owners must be aware of the crew composition, their travel history, amongst other issues. If not, this might pose serious ramifications ranging from quarantining the vessel as a whole, quarantining certain crew members, or even imposing travel restrictions, meaning which the crew might not be allowed to disembark or be disallowed shore leaves. In the UAE, for instance, very recently, the port of Fujairah had issued a circular stating, setting out certain guidelines on crew being allowed to disembark and disallowing shore leaves. Subsequently, the DP World issued a similar guideline setting out a complete ban on crew disembarkment, and which was followed by the Abu Dhabi ports thereafter a few days later. Similarly, the Indian government has very recently imposed a lockdown on 75 to 80 districts, thereby literally closing the financial backbone of India. The Directorate General of Shipping in Mumbai has also issued a similar circular stating that the master of the vessel has to issue a health certificate before arriving at the first port of call in India.
How are the delays in respect of cargo loading, unloading addressed in cases of lockdowns?
So most shipping contracts that are charter parties, they contain a demurrage clause, meaning which it is a pre-agreed market rate of liquidated damages. In case of delays, in general, a charterer is liable for the demurrage amount to the ship owner at a daily rate, at a daily pre-agreed rate, contractual rate. Now, the question which arises is, in light of COVID-19 and the circumstances globally, whether a force majeure clause in a contract, if there is one, will allow the demurrage to be seized. The shipping industry is well conversant with the legal maxim that the vessel being once on demurrage is always on demurrage. Universally, there are no exceptions to this rule. However, courts, particularly in England, have time and again held that for a force majeure clause or an exceptions clause to allow a demurrage from seizing will have to be expressly stated in these terms, thereby meaning which a force majeure clause will have to be unequivocally drafted, setting out the intentions of the parties in these terms.
What should shipowners and charterers bear in mind if entering into a new agreement for vessel chartering, considering the COVID-19 situation?
In terms of entering into a new contract, it is advisable that the contracting parties draft out a clear and unequivocal force majeure clause, and in addition, they might like to incorporate the BIMCO clause on infectious and contagious diseases, which was initially introduced in 2015 after the Ebola outbreak in West Africa. The terms of this clause are set out for both time and voyage charters. However, when incorporating these provisions, it might be advisable for the ship owners and rather the contracting parties to check with the P&I clubs for any liability in case of geographical deviation. In addition, the parties may also consider incorporating a quarantine clause whereby the charterer may or may not be liable in case for delays in case the vessel is quarantined or the crew is quarantined, thereby affecting cargo loading or discharge. In these tough and challenging times, parties are advisable, although protecting their commercial interests as far as possible, try and cooperate with each other and assist each other wherever they can, and try and draft their contracts in clear and unequivocal terms so that to avoid any potential and subsequent issues which may arise.